Hi everyone, welcome. So in this video, I am going to discuss the polity and governance related questions that were asked in the GS Mains paper 2 of 2023, which happened just last week, September 2023. So there were 10 questions from polity and governance, and most of them were straightforward or an interpretation or an analysis of the provisions along with relevant case laws. So let us go through the questions one by one, and I have given a model answer also here. So this will be uploaded as part of the description of the video. So you can even download it and use it if you want. So first question, constitutionally guaranteed judicial independence is a prerequisite for a democracy. Comment. So why this question was asked? Again, you should think, and that is how you link the current events to the questions and make a assessment of it. There was a lot of debate about the collegium system versus NJAC when Justice Chandrachud took over in November 2022. It went on till March 2023. Lot of discussion and debates, right? And then it died down, and for various reasons. But that why the government said wanted NJAC, because it wanted some representation in the appointment. But why the Supreme Court said no, collegium is the best system, we don't want to tamper with it, because they wanted that independence. But the question is about judicial independence. So here it is about listing down the various independence provisions in the constitution. So your introduction will be an independent judiciary is vital for a democracy, and in appointment there is independence with collegium. In removal there is independence now, because always there, because parliament only can remove the judges after a detailed inquiry by a special majority. There is financial independence, because the expenditure, everything is charged on the consolidated fund of India of the judges and as well as the Supreme Court, and similarly in the consolidated fund of the state, because it is independent judiciary both at the Supreme Court and High Court level. And restriction on further practice. A Supreme Court judge cannot practice in any court, a High Court judge not in any court except Supreme Court and other High Courts. So these are the provisions which ensure complete independence of the judiciary, which is important for a democracy. But guys, look at this. This is the conclusion that I wrote for this model answer, because the chances are that UPSC has asked this question because of the current event, and so you try and link it. However, the collegium system requires more transparency and accountability. The revised memorandum of procedure has to be finalized so that there is more transparency in the process while appointing the judges. So that can be an additional conclusion which you can write at the end of this question. Second question is a straightforward question. Who are eligible for free legal aid? As per the NALSA Act, these are the list of people who are eligible for free legal aid. And what is the role of NALSA in rendering free legal aid? So, the National Legal Service Authority is under the Legal Service Authority Act. As per their direction, the State Legal Service Authority or the District Legal Service Authority organize Lok Adalats. Lok Adalats will give speedy trial. There are certain types of cases like matrimonial disputes, contract disputes, non-compoundable offences, which can be, compoundable offences, which can be heard in these Lok Adalats, and they give faster justice. And through this process, there is free legal aid also, which is given. So that's a straightforward question which was asked. Then the states in India seem reluctant to empower urban local bodies both functionally as well as financially. Comment. So this is primarily about urban local bodies, right? And here, in fact, I would have brought it out in the key issues, right? Smart city, SPVs, etc. So here, in the first part, write about the provision of the constitution, and then write about what is the issue, why they are reluctant, and what is the way forward as per the second Administrative Reforms Commission. So key provision is urban local bodies or municipalities. They are constituted at Nagar Panchayat transitional area, small urban area and large urban area. And you don't have to elaborate about the qualification, disqualification and all, because this is about the powers, functional and financial powers. So state legislature may by law endow powers to the local bodies to function as local self-government institutions, especially for the matters listed in the 12th schedule, which includes urban planning, town planning, waste management, water management, etc. And for financial matters, state legislature may authorize the municipalities to levy its taxes and fees and collect them. But what are the issues? Lack of adequate devolution of powers, both functionally and financially. Some states like Kerala, Karnataka have devolved more, whereas some states like UP are lagging behind. The urban local bodies lack empowerment because of also competing parastatal agencies. What are parastatal agencies? Other government agencies which compete for the powers, which compete for the funds, like DRDA, right, which is for rural areas, but health societies, district health societies, water agencies, sewerage board, water supply board, these are all in metropolitan areas, but they are all manned by bureaucrats. And smart city SPVs, which is again in urban areas. So they are getting the share of powers and funds which the elected municipal bodies are not getting. And there are lack of adequately trained manpower and excessive control by bureaucracy over elected representatives. These are some of the reasons why they are reluctant to share power and funds with urban local bodies. And what is the way forward? The second Administrative Reforms Commission has suggested that instead of may, the constitution should be amended to say they should be empowered with funds and functions for the matters listed in the 12th schedule. So that is something which should be done so that the urban local bodies are more empowered. Next question is about Parliament. Compare and contrast the British and Indian approach to parliamentary sovereignty. So here, first comparison. See, both of them are based on, Indian parliamentary system is based on UK parliamentary system, which is the Westminster system of governance, where we have a legislature which is elected by the people and the executive is part of the legislature, right? So India draws its parliamentary system from UK. That is the similarity and the comparison, right? And in both the countries, parliament is the highest legislative body. But in terms of sovereignty, the British Parliament is sovereign because there are no restrictions placed by a written constitution in that country. Whereas the Indian Parliament is not sovereign because of the following factors. We have a written constitution. There is distribution of powers between the union and the state. So the state matters, Parliament cannot legislate unless under specific circumstances. They cannot make laws which contravene fundamental rights. And any law made by Parliament, including constitutional amendment, is subject to judicial review, right? And even the constitutional amendment. So these are restrictions on Parliament in making laws. But even for constitutional amendment, the Supreme Court in Keswananda Bharati case has said basic structure doctrine cannot be violated, right? So these are the things which place restrictions on the Indian Parliament sovereignty when compared to Britain. That is the answer that you need to give. Discuss the role of presiding officers of state legislatures in maintaining order and impartiality in conducting legislative work and in facilitating best democratic practices. So what is legislative work? So guys, and why this question could have been asked? Because of, Maharashtra crisis. Possible. I mean, that doesn't mean you have to explain the Maharashtra crisis. This is a static, generic question. This is very similar to the question which was asked in 2020. Once a speaker, always a speaker. Discuss whether this practice will make the parliamentary system robust if the Speaker of Lok Sabha is made like that, which is the British form, where once somebody is appointed as a speaker, they resign from the political party. They get elected in further elections only as Speaker of the House of Commons and not as a political party candidate to maintain the impartiality. That can be the conclusion that you can give here. But first, presiding officers of state legislatures, speaker, deputy speaker in the assembly, chairman, deputy chairman, right? In the legislative council, in a state having a legislative council, what are the role of presiding officers in maintaining, in smooth functioning of legislative work and democratic principles? Unruly behavior, they can suspend people or they can, issue notices for unruly behavior. They can even suspend members if there is unruly behavior. Legislative work, they are the people who certify a bill to be a money bill, just like Speaker of Lok Sabha, the Speaker of Assembly certifies a bill to be a money bill. They are the people who decide on the 10th schedule disqualification in the Assembly and the Council, right? But what are the issues? especially amongst legislative assembly speakers, because that is where the ruling government has to have a majority. They act in a partisan manner while conducting the affairs. 10th schedule, they take a lot of time to decide, despite Supreme Court directives. In KM Singh versus Manipur case, you can quote that case law. The Supreme Court said you should decide on any disqualification unless there are exceptional circumstances within 3 months. In Maharashtra matter, in March 2023, the Supreme Court said, March or May, that you should decide on the disqualification of the CM and other legislators. But the Speaker has not yet decided on it. Almost 4 months are over. Supreme Court has again given a directive to the Speaker to come out with a plan of action within 1 week. I don't know when they are going to submit it. So, it has been observed that presiding officers, especially Speaker of the Legislative Assembly, act in a partisan manner which favors the ruling party when it comes to conducting the business of the House, as well as disqualification of members. This can also be seen recently in the delay in decision making by the Maharashtra Assembly Speaker. In KM Singh case, the Supreme Court gave a direction that speakers should decide on such matters within a period of 3 months. And so, the practice of UK House of Commons, where the speaker once appointed resigns from his political party and continues only as a speaker. Even in subsequent elections, they contest only as speaker, not as a member of a political party. That may be introduced in India also for improving the impartiality, for improving the impartiality and for improving the independence. Next, e-governance. So guys, e-governance related questions and all, I always say this, right? There are some standard template points. What are the issues in e-governance? What are the recent trends in e-governance? Recently, how many e-governance related projects have been launched by the government? What are the issues in e-governance? And what are the possible solutions, including second ARC recommendations for addressing? So this template, if you have in mind, any question relating to e-governance, you can structure your answer around this. And this question is straightforward. E-governance is basically the application of ICT to the process of government. E-governance as a critical tool of governance has assured in effectiveness, transparency and accountability. What inadequacies hamper? So question itself is asking you to structure it like that only. But even other questions that are asked, you can keep these points and suitably expand or compress the points. What are the recent initiatives? What are the issues? What are the solutions or the way forward, including recommendation of the second ARC? So e-governance is for smart governance, various initiatives, G2C, government to citizens, G2B, government to business, G2G, government to government. And this is this has brought about transparency and accountability. Recent initiatives, direct cash transfer, lot of subsidies, PM Kisan Yojana. You can even quote those schemes if you want. PM Kisan Yojana, direct LPG subsidy. All these are directly transferred as cash. Old age pension and other pension schemes. All these are directly transferred as cash. So it brings transparency, accountability. It ensures that there is no leakage. Online monitoring of projects, PM Gati Shakti. Online portal for migrant laborers, Shram portal, right, have been enabled through ICT project and programs, right? I mean, you can quote those programs also as examples. But what are the challenges? Standard challenges: lack of adequate digital literacy, lack of support from the political leadership, no timeline for completion of projects, lack of adequate funding for such projects, delay in execution. All these are standard issues. And what are the measures? As the second ARC said, which continues to apply even today: building a congenial environment, political leadership giving utmost importance to these e-governance projects, mission mode projects for timely completion, re-engineering the business process itself so that it is in line with e-governance, capacity building of government servants. These are the ways which can ensure that what hampers the issues that we said, and these are the measures that can be taken for improving e-governance. The next question: Constitution is a living instrument with capabilities of enormous dynamism. It is a constitution made for a progressive society. So this is about how Constitution is a living document and how it is amended from time to time in order to take care of the requirements of the society. That is the introduction, right? Which you can write. Illustrate with special reference to the expanding horizons of right to life and personal liberty. So what are the factors which expand the horizon of, so introduction you will write simple 2 lines, it's a living document, it can be amended by the parliament by a special majority, and there have been various amendments that have happened, 106 amendments till date, which provides for changing circumstances. But specifically right to life and personal liberty, which is Article 21. Article 21 provides that no person shall be deprived of his life or personal liberty except according to procedure established by law. And what are the case laws to illustrate how it has expanded? In A.K. Gopalan case, the Supreme Court strictly held it as procedure established by law. But in Menaka Gandhi case, the Supreme Court overturned its decision in A.K. Gopalan case and held that the procedure established should be reasonable. So it is as good as due process of law, which should follow natural justice. And in various judgments, matters like clean environment, free legal aid, health, potable drinking water, all these have been read into Article 21 by the Supreme Court in various judgments. And in 2017, the Supreme Court declared right to privacy as an integral part of Article 21. And all these judgments have expanded the scope. And this privacy judgment, what all it has expanded? Section 377, which criminalized homosexuality, and Section 497 that criminalized adultery, have been struck down on the grounds that it violates the right to privacy. Right? The Digital Personal Data Protection Act, the DPDP Act, has been passed in 2023 to protect the privacy of individuals and the data of individuals. Thus, the scope and horizon of right to life and personal liberty has expanded over a period of time based on the interpretation of the Constitution. Next question, explain the constitutional perspectives of gender justice with the help of relevant constitutional provisions and case laws. So guys, this could have been asked because there was a talk that in the special session, Women's Reservation Bill will be passed, and that has in fact passed but the mains exam, GS paper happened before the special session started on September 16th. Special session started on September 18th. But that could have been the possible trigger for this question. Now in the model answer, I would have written that it has been passed because I prepared the model answer after the special session. But in the mains, you could have written that there is a proposal or there is a discussion that Women's Reservation Bill will be soon enacted, which will also provide for gender justice. That can be the conclusion that you can write. But otherwise, what are the gender justice? First, Article 15-16, no discrimination only on the basis of sex, no discrimination only on the basis of sex in public employment, equality before law, Article 14, all these are applicable to both men and women. So that guarantees equality of women in our country. That will be the introduction that you will write. But what are the other constitutional provisions? Apart from the guaranteed fundamental right, there are specific provisions that uphold gender justice. What are they? Article 15.3, special provisions can be made for women and children. Part 4, directive principle says adequate means of livelihood for both men and women. Equal pay for equal work for men and women. 39D. Maternity relief for women. 42. All these provide for gender justice. Article 51A, one of the fundamental rights says that citizens should renounce practices which are derogatory to the dignity of women. There is reservation of minimum 33% in panchayats and municipalities, both in members and in chairpersons. And now, I have written, further in September 2023, the Constitution is amended to provide 1/3 reservation of seats in Lok Sabha and assemblies. But you could have written that it is proposed or it is being discussed that the Constitution may be amended to provide 1/3 reservation even in assemblies and Lok Sabha. And these are the constitutional provisions for gender justice. And what are the case laws that you can quote? Vishaka, most important guidelines for prevention of sexual harassment at workplace. Triple Talaq case, which struck down instant triple talaq as unconstitutional, thereby ensuring gender justice for Muslim women. Sabarimala case, which allowed for all women to enter the shrine, though it has been referred to a larger bench for review now, that can also be quoted. And few other cases, if you can think of, you can quote, but these are some recent important cases. Vishaka guideline is though 97 case, but it's a very famous case for gender justice. Right? Account for the legal and political factors responsible for reduced frequency of using Article 356 by the Union government since mid-1990s. Now, if you want to make a link to it, Manipur government, whether it should be dismissed or not because of the breakdown in huge law and order and constitutional aspects there because of the Manipur crisis, which still continues, unfortunately. Hope it gets resolved sooner than later. That could have been the trigger. But anyways, this is a straightforward question. I mean, I'm not expecting you to overanalyze it, but whatever is in the news, ensure that you are revising all those areas under the constitution, not just for recall from a prelims angle, but also from writing an answer in the mains. So we will first write Article 356 allows for dismissal of a state government by the president for the breakdown of constitutional machinery. This has been misused in the past. It has been used more than 90 times in the past. Before 1994, but after 1994, after the SR Bombay judgment, its misuse has been largely reduced. What are the legal reasons? SR Bombay judgment. SR Bombay judgment said how president's rule should not be used for political reasons. The strength of the government should be tested only in the assembly till the parliament approves. It is subject to judicial review. If it is found unconstitutional, it can be restored till parliament approves the imposition of president's rule. There should be no dissolution of the assembly, right? All these, and it should be, your strength should be tested only in the floor of the assembly, not in governor's house and all that. And it is meant for breakdown of constitutional machinery. So these are the legal factors. Question is both legal factors and political factors, guys. Of course, legal factors is what you need to expand because that is SR Bombay judgment. But what are the political factors? After 1990s, we have had coalition governments since 1991 till 2014. Only now, single party, BJP as a majority. But between 1990 and 2014, it was always a coalition government with the regional parties also being part of the alliances. And so, most of the regional parties are against the use of Article 356 by the violating the federal principle of our country. And so, that is the political reason why the misuse of Article 356 has come down. And finally, explain the significance of 101st Constitutional Amendment, which is the GST amendment. What extent does it reflect the accommodative spirit of federalism? So, GST amendment was introduced to subsume the indirect taxes. It's a destination-based tax, so that the cascading effect of taxes is allowed. So, two things, guys. Cascading effect of taxes, tax on tax should go away. And secondly, it is based on the principle of equity, where the consuming state, the destination state, gets the share of the tax revenues. That is the essence of the constitutional amendment which should be brought out in the first part. And how it is for cooperative federalism, because the weightage of votes is 1/3 for center, 2/3 for all the states, but the majority required is minimum 3/4, which means center on its own without the support of majority, close to majority of the states, cannot unilaterally do anything. All the states together also cannot unilaterally do something without the support of the center, because they all put together have only 2/3, whereas the majority required is 3/4, right? So that is the discussion. I hope you found this video useful. And guys, just for people outside of Officers IAS Academy, there is a book called Polity Simplified, which I have written, and it is getting published by McGraw-Hill, and it should be available in the market sometime towards the end of October. And this is a document which shows how the content in the book can be used as it is with few modifications based on current events and other points that I discussed. But I would have given even the sections of the book from which the content can be directly lifted and written for the mains answer. So it should be available in the market from end of October. So feel free to get your copy and understand polity in a simplified manner. Thank you.